Welcome back. If you've just joined us, you're watching the Daily Roundup with Nina. Now, the African Judges Colloquium on Defense of Intellectual Property Rights is currently underway in Swakopmund. Joining us via Zoom to give us more detail on this is the Chief Executive Officer of the Business and Intellectual Property Authority, BIPA, Ms. Vivienne Katjiuongua. Ms. Katjiuongua, good evening and welcome to the Daily Roundup.
Good evening, Nina, and good evening, viewers, and thank you for having me.
Talk to us, perhaps as a starting point, about what necessitated, this academic conference of African judges on the defense of intellectual property rights.
Intellectual property rights are like other rights that, in actual fact, the ownership of these rights is better expressed in the ability for them to be protected and enforcement to be available in the countries out there. So intellectual property rights are bound by jurisdiction. So your protection is within that specific area. And we have different court systems across the globe, but specifically for ARIPO and for this specific event is that the ARIPO, which is the Africa Intellectual Property Organization, is composed of about 22 member states. And then it also has observer member states who are out there. And what they sought to do is to try and enhance the ecosystem of intellectual property within the continent. And by bringing these judges as well as attorneys together, is to create a network and a platform where they can discuss, exchange ideas, and learn from each other on the implementation of the different intellectual property laws that are out there, and also the way that they give effect to the different cases that come before them. I think the most important thing is for them to have an opportunity to discuss openly and to share ideas and experience on IP, but to build and maintain this network that they can always tap into when they maybe face a new case, and they can exchange views and enhance the intellectual property rights across the continent.
To date, how is the continent faring in terms of intellectual property protection, as well as the trying of cases pertaining to IP?
Yeah, so I think we have different levels of development and experience on the continent, like elsewhere. So you find certain countries would have a good legal framework where you can actually enforce the law and you can give effect to it. But it may be that there is no uptake. For example, the whole aspect of IP, it's not that challenged, or you don't have significant competition that cases would come before court, but at least the legal framework is there. Other jurisdictions are more mature, like South Africa, where you would find a lot of case law when it comes to intellectual property, and it's tested. I think in countries like Kenya is similar to that. So we have different levels of development, but the idea is really if you have those who are leading, you have those who are lagging behind, but it's to take hands and share the experience and know where to go in the event that a case like that would come to your specific court. I would say that we are really growing, because if you look at the extent to which the ARIPO member states are growing, and if you look at the whole discussion on Africa, even taking into account what is happening at the Africa Continental Free Trade Area, where they have now the heads of states in February adopted the IP protocol, which also then goes further to try and unify all the fragments that you find around the continent of intellectual property administration, as well as the legal framework that is out there.
I was also going to ask about, whether as a continent we have enough instruments to prosecute intellectual property, but you've just mentioned a couple of the disparities that currently exist. So what would be the immediate legal requirements that need to be instituted, not only to protect, but also not only to protect intellectual property, but also to prosecute, those that infringe upon this right?
So I can maybe use the example of Namibia. What we have in Namibia is we have a really modern industrial property law that is the enabling legislation when it comes to the domestic application of IP. And what it creates, it protects all the various intellectual property rights that you may find. Of course, not copyrights, because copyright we provide for in another legislation. And then it provides a framework where you can have alternative dispute resolution between the parties, where, for example, BIPA, which is the registrar's office, can hear different matters to try and find solutions. The other is there is a tribunal that is established that you can go to court, approach the court to at least hear the matter. The challenge, though, with most of our countries is that the court systems are already overloaded with other cases. And then what you would want is, with an intellectual property right, it's an asset, it's an intangible asset, and you don't want the case to wait forever while the owner or whoever is affected is suffering losses. So you want really an expedited way of solving these matters, and that is provided for in the legislation. So I think those are the types of solutions that we try to get. On the other hand, as a member of the regional framework like ARIPO, is that there are certain treaties and protocols that we have signed up to. Some of them allow us, for example, if I am an intellectual property right owner, I can then go and use the system to designate different countries to enjoy the protection. For us as Namibia, we, for example, don't have experienced examiners for patents, and we use the ARIPO examiners to then do the first initial examination, which is the substantive examination for us. And then as a national office, we would then assess those reports in order to make the final decision. So at least there is that level of support and collaboration between that. But I think we are growing because, as I said, all countries have different levels of development, but at least there are those frameworks or even international instruments like the TRIPS agreement that would apply to all countries, but you will apply them differently depending on the level of development of the country.
With the Judges Academic Seminar currently underway, what would you hope it brings forth, especially in how it changes the defense landscape and the legal environment in terms of IP rights on the continent?
So I think what we would want to see is that we really build and enhance the network that we are creating now, so that in that way, we are able to contribute towards building respect for intellectual property. Because if we build respect, then we know we are able then to showcase the value that IP brings with innovation and so on, and also to contribute to the development of our countries, especially contribute to the economy. But the network is really supposed to be a platform where, judges they are unique in their way of doing things, but they speak to each other as peers, and they can exchange information, tap into each other, and create this database of case laws that they have based on their experience. Because even if we are different jurisdictions, we might have the same legal history, so that you are able to use the same jurisprudence or case law that you would apply in Namibia that you get from South Africa or so. So at least they know where to go depending on the type of case that they have. But also they can debate amongst themselves with respect to existing or future developments in IP and how they would look at it. If you look at the current way where we are all moving into the AI area, as well as other areas where you don't know how are you going to ensure the enforcement of intellectual property. And it's things like that they would be at least at the forefront to discuss, and then see how they can find ways to give effect to the protection that, or the enforcement that is required when cases would come before them.
Well, Ms. Katjiuongua, we are rounding off our conversation, but I must add that, and acknowledge and commend BIPA for working so hard in its plan to protect intellectual property rights. But perhaps some final remarks from you this evening before we let you go.
Yeah, so I also want to add that in terms of the current group that is here, it's also composed of judges who have actually been tasked to develop a bench, a book, an IP bench book for the ARIPO region. So it's a book that would have various case laws that are set out there as a tool or as a resource, a book for member states and also other countries or observer member states. The other issue for us is really to encourage and really call upon the participation of especially the legal fraternity in discussions on intellectual property, and for us also to be able to advocate and take the message out there so that we can demystify this whole issue of intellectual property being seen as such a complex a complex subject matter that sometimes people are not even open to try and get their innovations and creativity protected. I think it's important because if you have protection, then at least you can take action against those who may be infringing upon your rights. So I look forward, and I hope that the Judges Network, as we move ahead, that they will maintain what is brotherhood, sisterhood that they would build, and at least tap into each other's knowledge and develop the case law for the continent.
Fantastic. Ma'am, it was so lovely speaking to you. Thank you so much for taking time out to join us this evening.
Thank you, Nina. Good evening to you.
That was Ms. Vivienne Katjiuongua, the CEO of BIPA, talking to us on the line. When we come back, we talk more on World Press Freedom Day.